the recording and we are going to start talking about doggett. So last time we all met, we talked about the Sixth Amendment broadly and all the rights enumerated therein. And specifically, we're talking about the right to a speedy trial, the right to an attorney, being the most important ones kind of enumerated therein. And we finished right before we were going to start discussing the very pivotal case of Doggett versus US. So now that we are here today to start that, who wants to start it off by telling me the facts, the legally relevant facts, while I pass around the sign-in sheet of Doggett? Go ahead, Joshua.
1982, the defendant was indicted for conspiracy to import and distribute.
Yep.
When they were sent to arrest him, they found IDs in Colombia.
Huh?
Then in 1981, he was in Panama. In 1982, he settled back to Virginia after passing through customs unhindered. And finally,
When did he come back to the US?
I said 1982.
Keep going, Joshua. You're doing a great job.
And then finally, he was arrested. They arrested him and filed a motion to dismiss due to violation of speedy trial.
When was the arrest?
They said it took 6 years.
Do you remember? 88 was it?
Yeah.
All right. Any other legally relevant facts, Joshua or anybody else? All right, great. Let's lay out the most important facts. Most important, but there are a few others that the court does consider, which we'll get into a little bit later. So we know the facts. Somebody wants to tell me. Somebody wants to tell me other issues, right? Go ahead, that's me.
After the delay of 8.5 years between docket indictment and arrest violating the Sixth Amendment right to a speedy trial.
You said indictment and what? And arrest?
Arrest violating his Sixth Amendment right to a speedy trial.
Great, that's me. Anybody else want to give me another one?
Question now.
Right, go ahead.
If he was arrested in a different country,
He wasn't. He was arrested here.
he was arrested.
No, he lived in Colombia. Then he moved to Panama. And then he returned to the US in 1982, where he lived openly. This is important. Held job. Held taxes. What else happened during this time period? Anybody remember?
Got a college degree.
Graduated college. Yes, he got married.
But he's doing all of this, like filing taxes and using things that use
Correct.
a social security number. How did that not qualify?
That's where we're gonna head to when we get to the explanation. So anybody else want to give me their formulation of the issue? But those were great. Those were also very important legally relevant facts. That he lived openly. He did not hide anywhere. He held an address. He owned real estate. He rented real estate. He held a job. He filed taxes. He graduated college. He got married. He had children. All things that generally put you on the radar of society, specifically the government. So we have one phrasing of the issue. Does anybody else want to give me something else other than destiny? Nobody? All right, then destiny is the winner by default. Destiny gets an A and you all fail. That's how law school works. Just kidding, mostly. But yes, I think this is still a great phrasing of the issue. First and foremost, one, because we have the very legally relevant fact of 8.5 fucking years between, and it's not just 8.5 years between like the time the trial started. The indictment and the issuance of the arrest is the problem. Because how would a case go through if we were not in this situation? About what's the timeline look like? So usually we would have that marker. Where'd I get one? You have your indictment. Then what would come after that? Comes after you get indicted in criminal court.
Get arrested
You may have already been arrested, and you probably already were.
if you're right.
Yes. And does anyone know what the rule between how long you have between indictment and arraignment is?
2 hours in Louisiana. 24.
That's if your first appearance. So for first appearances, which come before an indictment, that's right after your arrest.
I have a question. Isn't there secret indictments?
Yes, there are. Correct. There are sealed indictments as well. Give me just a second, right? After arrest. As soon as practicably possible. Usually 48 hours. Or longer if there's a weekend hold. So that's your first appearance. You've already probably arrested at that point. At that point, we then try to charge you with the felony charges, which would happen through information. Or remember, we could also have a preliminary hearing. Once a finding of guilt, or excuse me, once probable cause is found, we move to an arraignment, and the charges are, how long do you have between the time that the grand jury or judge decides there's probable cause before they arraign you? How long does that take? How long is this time period? Next court date. Or if we're at a preliminary hearing, it's gonna be at this court date. You're just gonna immediately arraign someone after the preliminary hearing, as long as probable cause is found over. So it happens pretty immediately, or like I said, by the next court date. And if we don't get an indictment to get to a point of arraignment after 90 days, in most jurisdictions, they'll dismiss for what we call FTP, or failure to prosecute. Meaning you've got the person in custody, you've got the information needing to give them probable cause, and you have waited 3 whole months and have done nothing with it. Therefore, you should dismiss because you are not prosecuting. And in my jurisdiction and in most jurisdictions, if no arraignment has happened after 90 days, after we've had the first appearance and we haven't gotten a preliminary hearing or an indictment, they're dismissing the failure to prosecute after 90 days. So the only thing that kept that from happening in this case was that Mr. Doggett missed the court date. Why did he miss the court date? He didn't know it existed, right? What was special about this one? As Nathan pointed out earlier. It was a sealed indictment. So in some instances, indictments or other information that is court documents can be sealed or considered to be secret or confidential. And when that is the case, the defendant doesn't necessarily already know it's happening. Why is this a problem for the prosecution going forward in the Doggett case? Somebody. Who was it?
If it's sealed and I don't know about it, it doesn't automatically implement failure to appear.
Yes, it's automatically what we call failure to appear, FTA. Failure to appear. What happens when someone fails to appear? Anybody know? Huh? Yes, it's called a capias warrant. A capias warrant is issued as soon as you fail to appear, which means there was an active warrant on Mr. Doggett's case from the time he missed the court date in 1980 to the time that he was arrested in 1988. What does that mean for the state? They need to check up on him. Love that. Do a Beyonce lyric. Check up on him. It is the state's responsibility. Always the state. And who is included in the state? The prosecutor, police, and all of these government agencies, especially UTSA. TSA, let's say Social Security Office, People who issue marriage license, so the clerk's office. Where else? IRS, thank you so much. Keisha. Yo, go ahead.
He had a warrant because he didn't complete support, right?
Yes.
So that warrant was from, it was 8 years ago, right?
8-year-old warrant.
Is that possible? Like, you
Yes.
have a warrant now?
Possibly you could have a warrant for even longer. Yeah. Until someone quashes it. This is how you spell that word. Quashes the warrant, the case is dismissed, or otherwise resolved, the warrant will stay active. Until someone recalls it by quashing it. Now, a lot of times, let's say a client missed a court date when I was a public defender because they couldn't get transportation. Super easy. I go down to the judge, I understand that you issued a habeas warrant in this case because my client was not here. If I am able to get my client here by end of the day, will you quash this warrant for me? Recall it. Yeah, absolutely. Get them in here by 5:30 today when I'm leaving and I will call it. They come in, they sign another court order that has the court date name or has the case name on it, has the defendant's name. It says, the previously entered warrant is hereby quashed. Defendant appears in person and with attorney. So ordered to judge, and then we're done. So it's very simple process. Let's get back into docket though. So why is it, the issue becomes, does this delay of 8.5 years between indictment and arrest? And again, I think that's the reason I like this particular phrasing of the issue so much. Destiny is between indictment and arrest violate the 6th Amendment right to a speedy trial. Because what do we think about when we think about speedy trial? Do you think about the time delay between the time you were arrested and the time that you were indicted? Ben says yes, but that's because Ben's been in my class too many times. Would you typically think that speedy trial also includes your pre-trial processes, like how long bond takes, or how long the discovery process takes, or how long DNA takes? Do you think that's included in your speedy trial right? Or would you have thought that was true before we started having this conversation?
I mean, it should be, because it's still leading up. It's still like. It's prevalent to your trial.
Love that. Okay, so let's divide this up into reasons why this is a problem, and reasons why it's not a problem of the government. Problem. What are the issues that we see with this case? And then what are the arguments against it? Let's do some fun debate here to prep you for your final. Start getting us prepped along that line. So what might be the argument if you are the government in this case? You're not Doggett, you're the United States. What is your argument that this is not a violation of speedy trial rights? What would you try to argue? Go ahead, Esme.
I feel like in a government like standpoint, like you would be like you should know there's something coming afterwards when you were already indicted for like transporting like an illegal substance.
We're getting at the kind of, let's say, maybe personal accountability. Follow up, say, hey, you knew you had a court date, you knew you had a criminal case, and you went your ass to pay them all, right? So what might be another government argument? Not just that he has personal accountability, he should have known once he was arrested that something was to follow. What else? How did they argue? He tried to flee. And he didn't just kind of flee, right? He didn't just like hop to California. He is out of the country. Multiple times, right? What else might you argue?
The extradition law, was that point?
I cannot honestly remember if extradition came in here.
Something.
I don't remember if South America extradites. Can't remember, to be honest with you. Go ahead, Gracie.
I can't remember, but did it say like why he got arrested in Panama? Like, did he get charged down there?
He did not get arrested in Panama.
They just like contacted the.
What was the final arrest? How did he get arrested here in the United States?
Predator.
So arrest here, where are we at? Because of a credit inquiry, which revealed that he had an active warrant.
Did you try to sue like TSA, IRS, and that stuff, saying they can see?
That's part of his argument.
Give credit for the.
multiple government agencies vetted him in his time periods, right? That's what his argument is, first of all, I did not know, just because an arrest happens, so that's another argument, right? Does an arrest always equal charges? No. And especially in his case, where it was a sealed indictment, how is he gonna know? What knowledge? You have to have, this creates issue of notice to the defendant, which is abbreviated as a delta sign. Notice to the defendant. That is a key cornerstone of your constitutional rights. Constitution is notice, and anybody else know what it is? Notice and cornerstone to our democracy is notice, meaning you know what's happening because someone has told you have been made aware, and an opportunity to be heard. Like we talked about in the First Amendment, to petition government for redress, to talk to people about the bigger policies, but also in an individual sense and a due process sense, to be heard on your case. To be heard on your case. To be heard. These are the cornerstone of it. So that's the cornerstone of their argument, is like, you have literally missed the point of all of due process. Give me some arguments in favor of the government in this case.
I believe he was arrested in Panama.
Oh, thank you. I'm not thinking was.
And so this could be an argument, is
Okay.
because Panama said, hold on, let me hear it.
Thank you. Grexy was correct. I'm so sorry, Grexy.
The DEA secured a promise from Panama that he would be expelled from the United States when the Panama proceedings ran their course. Instead, he was released and went to Colombia.
So the DEA was supposed to come get him.
After Panama finished with their deal, whatever they were doing. It doesn't say what he was arrested for there. But then Panama also never alerted the US about him going to Colombia and being released. So one argument could be that there was no cooperation between Panama or Colombia with the United States.
We'll say no cooperation. Because we don't know anything else other than there's no cooperation. But what does that help him on this argument?
It didn't matter, he had no idea, he could have been on vacation.
Wasn't the DEA supposed to make the arrangement?
Yeah.
Was responsible.
Yeah, it wasn't between him and Panama, he wasn't a mediator between Panama.
Yeah, he wasn't the mediator, is he? Are you the defendant ever the mediator between two police agencies? No, you're not. Police agencies are the communicator between each other, so the DEA was responsible for we'll just say transfer. We don't know what else it would have been, or pickup, and they didn't. And then he also went through TSA, didn't flag it. When he came in and out of the country, right? Go ahead, Chrissy.
It says that the court ruled on both of those, DA, TSA, and all those, that they ruled it as neglect on their part. For not reaching out.
Yes, so this is state neglect. This is a big legal reason why we don't go forward. When it is the state's fault, when the delay is on the state, which is the rule that we get in Doggett. When the delay is on the state, hang on guys, I'm trying to find a. I want this here. The rule as it's written. There we go, that was right, that's where I wanted. Again, remember, we're not looking at any, the precursor to this is that Barker case that we talked about, Barker versus Wingo. That was in the PowerPoint, this was 1972. So this was, his indictment only came like 8 years after this original case that decided this issue, where it said, we're not gonna issue any bright line rules, we're just gonna look at the totality of the circumstances and determine essentially who is responsible for the delay. That's what we got for Barker versus Wingo. So if we're using that kind of analysis, to look at whether or not there was enough. Or who was it, like, who would you guys say is fault in this case? If that, who's been the cause of the delay? What is the argument that Mr. Doggett is the cause of the delay?
That deep down, he knew it wasn't gonna go away. I mean, he knew he had charges.
They should know. He fled the jurisdiction. Anything else? But he did, he came back to the US in 1982, so just 2 years later.
Is this an argument for the reasons for the delay?
Yeah. He delayed, he fled the jurisdiction. All right, that gets us to when he gets back. Now, what's the state's argument gonna be for why they continued to delay for the 6 years that he was in United States custody while he got married, while he filed taxes, while he went to school? What's the argument? That it's not the state's fault, that it's his fault.
He didn't turn himself in and check on the status of the charge.
Right, this is part of their argument. Why is this a problem? Why is this a problem for the argument, for the state to make this argument? What? Well, one, he didn't know. That's a very logistical reason. What's the other one? Go ahead. Why would he? Why would he? So how? That's one question. What's the other problem? Do you have a title on yourself? Do you? I'm gonna need you to be a little more firm in whether or not you have to incriminate yourself. No. Which is interestingly enough, in the amendment that we skipped, that's probably why you guys aren't very confident in that answer. But we talked about Miranda a lot. You have a right against self-incrimination. Don't you think it's pretty damn incriminating if you're like, hey, I'm just up here to see if there's any warrants out about me. I got arrested a few years ago and I'm just curious. Does that seem like a thing we do? Does that seem like a reasonable expectation to hold everyone in society to? Because remember, the Supreme Court doesn't make just laws for Doggett. They're not just making the decision for Doggett, they're interpreting the Constitution. They're interpreting whether or not this delay is constitutionally okay with or constitutionally comports with your right to a speedy trial. That's what they're interpreting. They're not interpreting whether Mr. Doggett did something he wasn't or wasn't supposed to, or whether he did or did not do the right thing. They're interpreting the Constitution. Does the Constitution require this? And typically, like we've talked about over here, where we've created, the Constitution, one requires notice. Mr. Doggett had absolutely no notice. You could say he wasn't arrested, which is what the state said. He was arrested, but we know the contrary. Not all arrests end in charges. Right? Lots of people are arrested every year and it never goes anywhere. You could be arrested at a protest and never have a charge. It's just you could be arrested or put in custody. Remember that arrest is just defined as in custody and not free to leave. So do you even have to be technically put in handcuffs to be arrested? No. So what if he actually hadn't been in handcuffs? He just knew he was in custody and not free to leave. Would you have considered that arrested if you weren't in handcuffs? A lot of people in the room of color are saying, yeah, I still consider that an arrest. You should. It absolutely is. But for most of us, what do we associate with being under arrest? Handcuffs, right? So if you weren't handcuffed, would you automatically know to go and look for a warrant? Now, what if you had traveled multiple times internationally since then, and at no point did anyone stop you? And of course, you guys know what TSA is like. And remember, this was the 80s and 90s, so TSA wasn't quite as stringent as it was then. Let's just want to keep that in mind. This was still pre-2001. Wasn't quite as stringent, but what about a marriage license? Or filing taxes? I mean, I'm not calling my name. So if you're doing all those things and no one's saying, hey, just so you know, there's a federal warrant out for your arrest. You don't know if you knew that. And no one says that to you. What's your notice? That you're fine, you're in the clear, and that is a problem for the Supreme Court. It's a fundamental issue. If you do not have notice, you cannot report. It's the same issue that we have with overbreadth and issues with vagueness. They don't give you enough information to rely on it. Where that is true, the government cannot act. cannot restrict. And the second part of it, the state neglect. Because it's another part of key cornerstone of our Constitution is that it's the state's responsibility to prosecute, right? Who has the burden? Does the defendant have a burden to prove they're innocent? Absolutely not. Absolutely, Nathan. It is the state's burden to prove you are guilty beyond a reasonable doubt, which means it's also the state's burden to get you to the prosecution point. It's the state's burden to bring that evidence against you, to get it from the police officers, to bring you into court. If you are otherwise displaced, meaning you're out of the jurisdiction, it's their job to come get you. So the Supreme Court relies on that and said, yeah, you know, it's their fault, because how is the defendant, how is the defendant supposed to prosecute themselves and get themselves to prosecution? So we know how we might deal with an arrest, like how a defendant might deal with an arrest knowing they have an outstanding warrant. They could show up, turn themselves into a police station, say, hey, I now have a warrant. Please take me into custody and process me. Some people might do that, some reasonable people. Not many, but how would you go about prosecuting yourself? Let's just assume, let's say for the state, for the purposes of the Supreme Court argument, the Supreme Court agreed and said, you know what, he should have known. He should have known he was under arrest, or he was wanted. He had enough notice. But what about prosecution? How would he have prosecuted himself? You're attorneys for the United States. How would you have prosecuted? How should he have prosecuted himself?
The court had to, or he had to prevail that he could provide actual prejudice was proven against him between the delay that happened.
What do we mean by prejudice? Do we mean that they're judging him for what he looks like, what he sounds like? Is that what we meant in this particular case? No, shaking her head no behind Gracie. What does it mean? What does prejudice to the defendant in this particular circumstance mean? No, it doesn't mean what it traditionally means, which is that we are biased or judging someone based on information that we know about, let's say, their general characteristics, like their demographic as far as gender, age, race. What might prejudice mean in the legal sense?
The government wrongdoing.
Close. Right on track, yes. Good job, Gracie. And in doing so, they wronged him and harmed his case, so that he is prejudiced in building his defense. He lacks the ability or it has been affected. So the prejudice has to do, not necessarily with how people see it, but that the defense is essentially kind of hamstrung from the beginning. So if it was 6 years later and he has lived abroad and now he's back and he's married to for a person that we assume that he didn't know beforehand and all this other stuff, how is he supposed to find witnesses or any individuals who were connected to this 1980 indictment? And remember, this is 1980, it was way before the times of cell phones and the ubiquitous use of the internet and the ability to find people just like with GPS systems. So how would he have done that in the 80s?
Would it just have to literally drive, essentially just go to every location or
Can you argue that they lost, like, they had on him in 8 years too? Did they actually keep up with this one?
Right. So this is essentially what the court is going to balance. And that's what the court says is going to happen in all these cases post-Doggett. We're going to balance, determine who's most at fault and who really suffered the most from this delay. And that's the person that we're going to side with. So instead of there being a bright line rule that like we always side with the defendant because they have the right to a speedy trial, which they should have been ruled, but I'm not on the Supreme Court. What do I know? they say, we're going to take it case by case, and we are going to determine whether or not it happened. Basically, whose fault it was and what were their reasons? Were they really good reasons for delay, or were they just kind of not paying attention? So in this particular case, we know the reason the big delay happened between indictment and arraignment. It didn't happen post the arraignment, which is normally when people start asking for continuances. And if you'll remember, when we go back to that Barker versus Wingo case, where this rule comes from, in that particular instance, the prosecution had requested continuances post arraignment. So the arraignment is in, we are here, we're post preliminary hearing, we're at arraignment. So we are beyond where Mr. Doggett was, and instead we're here. And then to trial can sometimes usually take 2 to 3 years. And the Barker versus Wingo case, it took 5. And they had multiple co-defendant trials during that time in which the prosecution was getting continuances. And the Supreme Court in that case ultimately said, no, this isn't good enough. The prosecution had very good reasons for requesting the continuances. They needed the guilt of the first person to establish their theory for the others. And the accomplice also did not assert their right to a trial. What is different here in Doggett? Oh. Asserted right to trial as soon as he was arraigned. So in the factors that we got from Barker, this is a huge factor. Remember, what did I tell you about whether or not I as a defense attorney would do this? Who recalls from that conversation? Do I assert my client's right to a speedy trial at arraignment? No, why don't I?
Because you want to be able to.
Yes, because I want to be able to continue to gather evidence in this discovery period between arraignment and trial without saying, I need more time. Because if I say I need more time, then do I have a very strong argument on this side that it wasn't me that needed the delay, it was the state? No, I don't, because I requested the continuances. But if the defendant asserts it as a person and says, hey, I'm ready for trial right here, right now, the court still recognizes it, but doesn't hold me as the attorney to this timeline. They do, however, hold the state to this timeline because the state is always held to the constitutional requirements. Now, once someone asserts their right to a trial, what's the number of days and or months that they have to get something into court? I said it last time, only mentioned it, you might have thought it. 90 days is usually to get a finding of probable cause. What is it? 180 days. About how many months is this? They might know.
6.
So roughly 6 months to do some shit. Now, we know that 5 years is not necessarily considered a violation of speedy trial, but where the defendant asserts his right, you got 180 days to answer something. And you better state, have a good reason that you're not. Because if not, I'm going to file a Doggett motion, and I'm going to file a motion to dismiss based on the violation of the speedy trial right. And depending on how serious the case is, the court is going to weigh certain factors like what are the continuing delays for this case, especially if it's a very serious case with the 180 days. No, judge is going to dismiss this. Doesn't matter if my client has asserted his right. It doesn't matter. I'll go in and make the argument for my client if they want me to, right? But if it's a murder case, am I going to have DNA evidence after 6 months or 180 days? Probably not, and in fact, definitely not. Are all the witnesses going to be prepared? Are we going to be able to get a trial functioning in a courtroom with the lawyers and all the witnesses and all the evidence and all the law enforcement officers all off schedule at the same time in 6 months? Probably not, because your attorney is probably trying the case from 6 months ago that they now need to try. So it's not really going to happen, but you can continue to reassert your Doggett rights and say, hey, it's been another 180 days. I want this issue taken up. I want my attorney to file, and I will. I'll continue to file it every 180 days until we get to the point where either we're at a trial, we're finally having a trial, or the judge will dismiss it for failure to prosecute. Now, whether or not the judge dismisses it and it can come back is a matter of whether or not prejudice has been established. Now, when it comes to the factor of prejudice, this is the factor the court weighs. Who was more prejudiced? Are there certain cases in which time can prejudice the state more than the defendant? Can you imagine a criminal case or a set of facts in which delaying it would help the defendant, but not the prosecution? Joshua is going like this, yes. Go ahead, say it again. Yes, DNA deteriorates. What about a case that relies solely on someone's memory? Right? Don't we think the longer that delay happens, the more helpful it is to someone who really needs that, who really doesn't want that memory shared? Going back to Harry Potter. Alter that memory. No, just kidding. But the longer that's there, the longer that stays. What about a delay? What other kinds of delays might help a defendant? In what other ways? Memory might get lost, evidence might get lost. Victoria?
I mean, they could like go through like some sort of PTSD. but, like,
Yes,
all those
absolutely. Mental health issues could crop up that affect someone's ability to be a witness. What about other logistical issues? Might the officers involved move out of the jurisdiction? What about the witnesses? Might they also move out of the jurisdiction? Or die? Or like Lorena said, retire? That's a lot to happen in 8 years, right? And what if those things happen, they're gonna affect the decision one way, or they're gonna affect the case one way or the other, and that's why one of the key factors is prejudice, and who was prejudiced. And most specifically, in this particular case, or going back to the Barker case, the precedent for Doggett, it said essentially that there wasn't enough prejudice to the defendant. Wasn't enough prejudice. All those trials were happening the whole time. Although he was asserting his right and objecting to the continuance, there wasn't any prejudice. He could not prove prejudice. What is different about Mr. Doggett? He could prove prejudice. How did he prove prejudice in this case? How did he prove that he was prejudiced in this case? There's an interesting line in here. But that proved that he was prejudiced. You guys have kind of already talked about it. In a hypothetical sort of way. Brandon alluded to it a few moments ago. Officers might retire. What else might happen? What else happened for Mr. Doggett's case? Victoria?
Like I mentioned earlier, to be filed taxes and everything, including the life, marrying, to a job.
Absolutely, absolutely. And now all those things might be not there anymore. That's real prejudice to someone, right? What else was real prejudice to his case? Again, remember we're talking about prejudice to the ability to defend. That might be more helpful. Prejudice to defense or the ability to do so.
Did the agent in charge of them do something? That sounds like
Correct.
what you're getting at, but
Yes. The officers involved were no longer a part of it. They had, or there was no longer information. There was also key witnesses that he would have presented, but he no longer had the contact information for. And of course, it's not like it is now where you can just Google that information or find it or locate it. If you no longer have it and you've since left the country, come back to the country, it's been 8 years. Do you think you're going to be able to get in touch with someone you knew 8 years ago? Or who knew you 8 years ago without any cell phone, without Facebook, without any social media? How would you do that? Right.
You would have to like send letters.
Yes. You would have to like put notices in the paper. Hey, I'm looking for you, or send letters to the final or to the last known addresses. Hey, I'm looking for you. Yes, right.
The things were like, if his witnesses were under age and
Yes.
and if they like 8 years, you change it.
You absolutely change within that time period. And also, like we said, your memory deteriorates. How are we going to guarantee, even if we can find those witnesses for them, that they're going to remember jack shit about it? But who has a perfect memory of this incident? Because it is it is solemnized in a written document. Right? don't they keep a written record of exactly what happened 8 years ago, so that if they forget, they can be put on the stand as a witness, and the prosecutor can hand them their police report and say, did that help you refresh your memory? Now, do you think their memory has been refreshed, or do you think that they're just reading their memory as it existed at the time? So they're allowed to do that. Who can't do that at this point, because it's been far too long? Absolutely. So that's where we're coming down to the issue of prejudice. In Barker versus Wingo, they said, we're not gonna hold it to a bright line rule. We're gonna weigh these factors. Did the person assert their right? How long was the delay? Who's responsible for it? And can you prove prejudice? And in Barker, they said, no, we can't find any of those things. Therefore, not a violation. In Doggett, we have an assertion that happened at arraignment. We have an 8-year delay between arrest and arraignment. So not between arraignment and trial, meaning a lot of things happened, trial and the discovery process, which is what happened in Barker versus Wingo. There was a lot that happened. There were 4 criminal trials that actually did go on during that 5-year period. And the court's like, hey, if you needed those trials to get to this one, of course it's going to take you that long. And that's not exactly prejudice. All those witnesses are continually coming to court. Their memories are continuing to be refreshed. Same thing with the officers. We're not seeing the prejudice. Here, nobody knows where anybody is. Nobody has the ability to locate anybody. We have an assertion of the right. We have an even longer delay. And the biggest thing, which is we didn't have any notice of the defendant. That's all of the state. The state's job is to notice the defendant. It's their job to bring them in to arrest them. It's their job to bring them in to book them. Their job. You can't do that for yourself. Much like the neglect of the prosecution. You cannot prosecute yourself. Although Mr. Doggett could have walked into a police station and said, hey, I got arrested a few years ago. I think there's a warrant out for me. And that could have resolved the notice to the defendant. It would not have solved the state's failure to prosecute. Not have solved it. They did not do anything. It didn't solve the DEA's failure to pick up for transfer. It didn't solve the TSA's failure to flag. It didn't solve the IRS's failure to flag. It didn't solve the clerk's office failure to notice or his job. It took a credit agency running his credit to buy a house, I think, or something like that, before anyone noticed. And when that's the case, that neglect is so bad, you are definitely prejudiced. We can presume prejudice. And in fact, in this case, the Supreme Court says we can presume prejudice prejudice is presumed after 2 years. Presumed. But until that point, which is why I said you can always expect 1 to 2 years on a serious case, and the court is not going to bat an eyelash at it. Or after you get to a certain point, though, the court's going to say, we presume there is prejudice because it's been too long. Actually, I think that might be 4 years. I think I might have misspoke. It might be 4 years. But in this opinion, that court has. So what is the breakdown on Doggett? What's the split? Yes, go ahead.
So if they presume that 2 to 4 years is too long and then consume benefits on that.
Yeah.
Then why did they even go through, why is it just a post decision that if it's already assumed that?
So glad you brought that up, Joshua. Why do we think it's a close decision? Remember, what time is this? What do we know about, it's true about the 80s? What court is this? Warren? Not Warren. Warren is who we love as far as due process. Who follows him that is not very great about due process? Rehnquist. So this is the Rehnquist court. This is a conservative appointed judge, appointed by a conservative president. During the 1980s, during which policies developed during the 1980s? Crime policies. What else? Just say no. Great. What else? What would we generally describe these policies as? Are these rehabilitative? What would we call them? Strict. Another word for strict might be. There's the T. Or to write this way. Tough on crime. on crime policies in the 1980s. Right? We are getting that flack, we're getting that pushback after we saw a huge 1960s and 1970s move of civil rights and due process revolution. Then the conservative court comes along, we finally get a conservative president. Conservative president appoints conservative justices start making policies that are in line with what the nationally elected presidents at the time had done. Who were the presidents during the 80s? Reagan,
The first Bush.
HW, and right on the tail end was Nixon. He came in, scooted he led us into the 80s era, right? So Nixon, Reagan, HW. War on drugs, war on poverty, tough on crime. We see the result of those kinds of policies come into, so of course, they're going to build factors that are generally positive for the state and give the state more wiggle room and give the defendants less. So it's a 5-4 decision because we still have certain members on the court, like Thurgood Marshall, who's still rolling around at that point. Bless him. Holding on to the 5-4 vote over here. So that's why it's a pretty tight one. What does that mean as far as that split is concerned? Like if this were to come up now and someone had been, let's say pre-trial, in some version of pre-trial for 6 or 7 years, do we think Supreme Court might go the same way on this case? It might get overturned. It also might not, because remember, Barker versus Wingo and Doggett are not bright line rules. They didn't establish a very strict rule. There was a pretty strict rule before Barker versus Wingo and before Doggett. It was in a case called Jackson, which held a pretty bright line rule and said you could presume prejudice after 2 years. And then this one said, no presumed. We're just going to do the general. You're gonna get the weighing of the factors and who's it is. You also have to, a big outcome of this is that if you're going to assert it, you have to affirmatively assert it. You can't just generally say, I have a right. It's much like that we talked about Miranda. You can't just not talk. You can't just want a speedy trial. You have to affirmatively assert it. So on the court record, you or your attorney have to file a document that says, I am asserting my right to a speedy trial. I want this matter disposed of as soon as practically possible or within the next 180 days. What would that do for courts if we held everybody to the standard? If everyone asserted their right to a speedy trial and said this, what would this do to court? Our legal system? It would absolutely break in half. Probably not even half. It's going to shatter into 1,000 tiny little pieces. So can we also see the realistic reason that Doggett comes down this way? Because what is the reality if Doggett had created a bright line rule and said anything after 2 years is too long? A lot of cases. So many cases. And what about cases that, let's say, are in various stages of resolve, but they're not quite resolved? Like, let's say there's a plea that's happened, but probation hasn't gone on and probation has not been resolved. And typically we say you can't be on probation more than 5 years with a 1-year extension. So 6 years max for a felony. And what if someone has been on probation for 10 years? Just because their probation clock has started so many times. Does that seem like it runs afoul of the speedy trial issue for you guys? Or potentially even cruel and unusual punishment if you never know when you're going to be off the hook for something? I think those are going to be the next areas that we see because the court, again, refuses to do that. Because there's a very real problem with setting a bright line rule. And that is that the criminal legal system cannot support it. So instead, we have to balance the factors that come into each individual case. Because if we apply the same rule for each case, it makes sense that you could resolve a stealing under case in 2 years, right? It's kind of like if you haven't, what's wrong with you? But what about, let's say, multiple person homicide where there are multiple defendants? Logistically, just logistically, not legally speaking, logistically, what do you think are the issues with that? How many defendants do we have? 4. You have to arrange 4 schedules right there. How many attorneys do each of them have? 1 to 2. So that is between 4 to 8 defense attorneys. let's assume they appointed one prosecutor, and they probably did. One prosecutor managing 4 defendants and 4 to 8 criminal defense attorneys' schedules. Now, you're probably gonna have at least one detective, a patrol officer response, you're gonna have a medical examiner, and you're gonna have probably at least 1 witnesses. That's assuming this is a very simple, multiple homicide case. That's at least 4 other people's schedules to consider. Now you have to consider the court schedule. How many weeks is a court open? Okay, don't say 52. Judges don't work on holiday weeks, guys. If it's Labor Day, anytime around the Thanksgiving holiday or the Christmas holiday, I believe as you Christians call it. Any other holiday that requires a 3-day weekend, that's usually chopped off and is not made into what we call term weeks or jury weeks. Meaning there's no jury available that week. So maybe during the year, there's like 35 weeks you can try a case. And now you have to coordinate schedules for trying one of those weeks that works for 8 defense attorneys, 4 witnesses, your judge and yourself, and 4 defendants. And again, that's the best case scenario with a multiple defendant indictment. That's not if we have more than 1 witness or more than 1 medical examiner, or we don't have any lab technicians, or we don't have more than 1 police officer, which if it's a multiple count homicide, we're gonna have at least probably 4 police officers and a detective come in. So logistically, you've got a lot of problems that's not gonna happen. Versus a stealing case, you might have 1 officer and 1 person to testify that that's the property that belongs to them. We see how logistically creating a bright line rule for treating both of those cases the same would be a problem. That's what the judges are responding to. So it seems very much, and I know it can seem very much in these particular cases that the judges are responding to something bigger, or that it's really unfair, we can't figure out why. Well, some of that is true, and some of it is strictly because the logistical explanation or the reality of trying to schedule these kinds of cases, or even at the federal level or the state level, to have a very bright rule of like 2 years, 3 years, no exceptions, creates more problems than making a decision in this creates. Does that make sense? So as much as we like rules, we want to hold them to strict, the court is recognizing if we put a strict rule here in place, we are going to fail. And the Supreme Court can't fail, remember? So we're gonna set ourselves up to succeed, and instead we're going to do this. What does the dissent say about this decision? If they take a couple issues, and I'll tell you where they take the issues. What do they say? What's their concern?
It seems like at least Thomas kind of used the fact that he didn't know it against him by saying that he didn't under any ability to defend himself or any stress or anxiety or whatever, because he didn't know about it. So it didn't harm his way of living or his liberty in any.
Yes, so the defense is saying the possibility of prejudice isn't enough. We want you to prove prejudice. That's what Thomas is saying. The possibility of. The main court says, we are going to presume that that prejudice exists at this point in the 8-year process. We're too far gone for us to presume it doesn't exist. Thomas says, there's no proof in the record that it did exist, and I'm not willing to assume that it did.
O'Connor mentioned exactly that. That speculative harm is not good enough to count as violent.
Speculative harm is not good enough.
They would have to be specifically proved.
Yes, have to specifically prove, which is similar to their doctrine on prejudice when it comes to proving prejudice in the jury selection process, which I think we'll probably read more about if we actually get through all the material that I have claimed thus far. Because the Supreme Court says the same thing there. It's not enough for us to assume or suggest that the prosecutor was eliminating certain jurors of a certain race or nationality or ethnicity because they were being racist. That's not enough. You have to prove it. Same thing in their prosecution. You can't prove prosecutorial misconduct or prosecution based on someone's race, or you can't just suggest it. It has to be proven. There needs to be some more direct evidence. So Thomas and O'Connor, interesting thing about O'Connor, even though she's first female court, female justice appointed to the court, was appointed specifically because she was conservative, because during the 1980s, when she was appointed, or excuse me, in the 70s when she was appointed, the spot opened up on the court, or the person who was running, excuse me, on the Democratic ticket at the time said, I know a person on the Supreme Court is going to become available during my tenure, and I am making a point that I'm going to put the first woman on the Supreme Court. Much like Joe Biden did when he said, I'm going to put the first Black woman on the Supreme Court, and that got him a lot of votes. So in response, the Conservative Party said, hey, the Democratic Party already promised this, and if we don't come through, we're gonna look like bigots. So find us a conservative female justice. And that is how Sandra Day O'Connor got appointed to the Supreme Court. Not unlike the person who also dissented with her, Justice Thomas, who Justice Thomas replaced good old Thurgood Marshall, back here in Barker versus Wingo in 1972, got his job the same way. They didn't want to put another white man on the court because they did not want to look like they were the party who was not being responsive to the issues raised in the 70s. This was the 80s right after it. So they said, all right, find us one other justice in the entire world who is Black and is conservative. That is how Clarence Thomas got his job. So for somebody who hates affirmative action policies, you should really rethink that, in my opinion. But that's just me between us. Anyway, so the dissent goes on to say, it's not enough to prejudice, you need to prove it. What do you guys feel about that? Would you think it's fair to make a defendant prove that they've been prejudiced? And if so, how would you go about, if you were Mr. Doggett, proving that you had been prejudiced?
That was gonna be my question, is how, unless you have a reporter or something, you know, I mean.
Would you prove you were prejudiced?
Based off of neglect that we can use upon the times that IRS, Social Security should have called.
For sure. Thomas is saying, we don't see enough prejudice in that. We hear you. Neglect isn't intention. So how would you prove prejudice? They intended it.
Did they say that he had firmly asserted his rights, or did they say that he didn't?
I can't remember from the dissent if they take much issue with the affirmative assertion of right. They take much more issue with the prejudice and the fact that he couldn't prove prejudice, that the other side was, or excuse me, that the majority was willing to assume it, given the delay. And that he talked about the potential being memory and the fact that he couldn't even contact with anyone. And the dissent says, you have some inclination that there's prejudice there, but you haven't proved it to us. We want you to prove it. How would you prove it?
You know, argue like the times that he asserted it, like it was like recorded on video.
Yeah, you could.
Many times.
You could argue that if you had a record to establish what happened. How else would you prove prejudice? How would you prove that you can't get in touch with witnesses anymore? How would you prove that they can't remember anything?
Once you find them.
Right? So it kind of asks you to do something impossible, prove your case first, and then prove that you were prejudiced by the delay. Kind of asks for the impossible, which is not, again, unlike what the court essentially does in Batson and in other juror rights cases or other questions of due process or equal protection, where they said you have to prove prejudice. How would you prove that the prosecutor was racially motivated in how they acted in your case? How would you prove it? Lauren.
Could like conduct or do like a survey to kind of get the gist of where we stand, but it's also very easy to kind of lie.
Yeah.
Just because you know, you read the room, so if you know people, you know how people are, you try to put
Absolutely. It's very easy to fake that you're not a racist. White people have been doing it for centuries, right? So how would you prove the absence of a fact? Very, very difficult. Are there ways you could do it? Sure, possibly. But ultimately, I think the reason that the dissent loses out on this requiring proof of prejudice is because in lots of situations, especially this, you'd be proving the absence of a fact. And it's ridiculously hard to prove the absence of a fact, because the only reason that you know it's existing is solely by its absence. Kind of like, how do you know like the difference between hot and cold? We know something's hot and we know when we experience cold. one of those kind of things. This is that situation, the dissent is very much saying, well, you can recognize hot and cold anyway. The majority is saying like, maybe you can, but it's been 8 years, so let's give them the benefit of the doubt. Questions about this case, or what it means for your right to a speedy trial?
I have a question.
Yes, Nathan.
Not criminal based, but how does the right to a speedy trial or the Sixth Amendment fall into like family court or custody battles or?
Great
because those can be
question.
delayed and.
Yes, it can. What, does anyone have a guess as to what the answer to Nathan's question would be? So do we have a speedy trial right when it comes to like family court? And that's specifically like, let's say, parental termination of rights. Or foster children situation. So not like a divorce, because we know those can go on for literal years. That's a civil matter.
But what I'm referring to exactly is like having the kid,
Yes,
delaying it till the kid ages out.
yes, that process. Does anybody know if that's civil or criminal? It is civil. Does anyone know what the termination of parental rights is called in the legal community?
If you didn't ask.
I've definitely said it before in some class. It's referred to as the civil death penalty. Because this is the worst thing that someone can make happen to you, is to take your children away. And they can do that. It's you, like normally, remember you had you are entitled to the life, liberty, pursuit of happiness, and none of your persons, places, papers, or effects can be searched or seized without a warrant. Would you not consider your children to be one of your, at least part of your person, or if not your thing or your effect? So yeah, so they have to have some due process to be able to do that, right? So there are due process benchmarks for parental termination proceedings. Does anybody know what they are?
Have like a status hearing.
So generally what happens is,
mediation.
yeah, there's several along the lines. They could go on for a while, and it depends because the goal of parental termination proceedings is actually not to get to the termination, it's actually reunification. The entire time the goal of the team addressing the family issue is supposed to be reunification of the parent with the child. And the only time that termination is supposed to happen is when we can make no substantial efforts toward that. And usually what's going to happen is a guardian ad litem is going to get appointed. That is an attorney who represents the interests of the child. Best interest of the child is the standard in that court, much like in juvenile court. Best interest of Lorena is shaking her head because she's been in juvenile delinquency, and we all know what a shit mess of a standard best interest of the child is. Because does anybody ask the child what they want? No. Absolutely not.
Especially if you have a shitty attorney.
Especially if you have a shitty attorney. They're not concerned about what the child wants whatsoever. Or if they have a bias against mom and dad. They think mom and dad have used drug before, therefore they should never have their kids around before. Addicts are great parents all the time, every day. Recovering addicts are great parents all the time, every day. But certain guardian ad litems will get appointed that view your parent a certain way and will not look at any of the things that you're doing. Then you're going to have to meet benchmarks. So you'll have status hearings to figure out, did you complete your parents recertification class or something like that? Did you complete emergency skills training? Have you attended all the family counseling sessions that we asked you to? And then if you get along those points and you're checking all the boxes, then they're supposed to reintegrate your child back into your life. So you're supposed to have more and more visitation with them. They're supposed to have overnight visitation then. But if we start going the other direction where none of those things are happening, then we move farther and farther to the termination process. And I imagine you would have a speedy trial right to that in some regard, but there's not a lot of great case law on generally the termination of parental rights, other than the state really needs to prove it and prove it big time. And like they need to be a very serious attempt to have reunified the parent and the child. And if not, then the court is not going to uphold that termination, because we consider the termination, and it's written in court documents over and over again, the termination of parental rights to be the civil death penalty. It is the worst thing that civilly can be assessed to you, is to have your children taken away. Lorraine.
It's a speedy trial and so it's like a silent case or so.
Such a great question. Are immigrants citizens of the United States?
No.
So do they have a Sixth Amendment right to speedy trial?
No.
No, they do not. tied up that loophole real nicely, didn't they? That's an excellent question, given the climate of the country right now. Does anyone know how long it could be taking to get deportation proceedings? Let's just say they say, we are going to try to deport you, which actually happened to one of my clients served between 5 to 6 years pre-trial, waiting for his trial, and then he was found not guilty on all 30 counts. And then the immigration services came for him, even though he had been living in the country legally married for 20 years prior to his criminal charges being issued. So immigration came for him immediately from the jail, picked him up from the jail. So we didn't even actually get to see the client get released, even though that was supposed to happen. And immediately went to, fortunately, they knew it was going to take so long and that he was married. They gave my client a bond. That client is still in the middle of deportation proceedings. I left St. Louis in 2019. Still haven't decided whether they're going to deport him or not. And he has been, again, legally in this country for 25 years, married to an American citizen prior to any of this criminal case happening, and he was found not guilty on all 30 counts after a jury trial.
Then how could they deport him if he's been here?
Do deportation or other immigration proceedings require a finding of guilt beyond a reasonable doubt to initiate deportation proceedings?
No. If you get like arrested or even pulled over, like you're gone.
Yep. The standard,
Have like papers here. Consider if you're a resident and you get like arrested, like they can make a very strong argument, unfortunately, especially depending on where you came from and what you got arrested for. Because I mean, if you're Hispanic and you got arrested for having drugs, like cocaine or something,
Yeah.
like they're definitely gonna be like, oh yeah, you're like, you're out of here.
or I had a client who was arrested on, he was in a, so when I say a fight, I want to be very clear, this was a misdemeanor. So at most, there was some punches and some scratches, some bruising and some scratches at most. He was in a fight, when he was intoxicated and a person who was experiencing homelessness was intoxicated, both on Wash Ave, which is the St. Louis equivalent of Beale Street. They were both drunk, they both got in a fight. My client, who was an immigrant, got arrested. And the second he bonded out, I never heard from him again. Guess where he went? He was deported, for sure. And I begged his mom, please do not put up his bond. I know what you're thinking. It's gonna get him out. He would be wrong. He's gonna get deported. We never saw him again. Now, it's not a misdemeanor. So the standard, when it comes to people who are not legally in this country, is generally in any kind of allegation that they're involved in criminal activity is enough to get them deported. Even if you are like here legally on some kind of, let's say, a student visa and you engage in some kind of activity, that could be enough to have your student visa revoked and you be deported. You're held to a different and higher standard of conduct than American citizens are. And again, you're not entitled to the due process rights because you are not a citizen. And you are here basically on the United States good grace. And they can revoke that at any given time. And no, they don't have to do that quickly. Because again, you are not a citizen and you are not entitled to speedy trial rights. Any questions? What?
Then why is Biden just allowing?
So why is Biden just allowing it to happen? This calls for a bigger commentary on what, this is not just a legal question, it calls for a bigger commentary on what's happening socially right now,
Maybe trying to get moderate votes.
right? We have any other suggestions? I think that's what's happening. I think he's trying to get moderate votes. Because what are people afraid of in this country?
What they don't know.
What they don't know. And an immigrant, no matter what country they're from, is always something they don't know. It's not a culture they know. It's not an ethnicity that they know. It's not a person that they know. Sometimes it's not even a name that they know or can pronounce. God forbid, we have to learn how to say things in a different way, right? Or using a different accent or a different stress of the syllable. God forbid. What else is socially happening? Because we're not just trying to appeal to moderates. This isn't a normal presidential election. Who are we running against as far as the Democratic concern, or Joe Biden, the Democratic candidate is concerned? Trump, right? What are Trump's policies on immigration? Making Mexico pay for a border wall.
Very extreme.
very extremist,
Separating their children.
separating. Right? So if you're Joe Biden. So here is one side, so here's the political spectrum on immigration. And you are, or Trump's over here, we'll just put him off the scale in the first thing. He's off over here, believing that everybody who comes into this country commits crime or is some kind of derelict, some shape, form, or fashion, forgetting that we all came from a different country at some point. But apparently, again, over here with revisionist history, Trump. Then we have Joe Biden, who I would probably put somewhere over here. Let's just say moderates right there. Then we got Joe. Because keep in mind, what is also true about Joe? How did he get his start in public service? I don't know what happened back there. I assume it was hilarious. What did you say? He does fall a lot. He does fall a lot. He what? He was vice president. How did he get his start before then? Way back in the day. And also, if anybody wants to see a fun fact, or see just like kind of how long people stay in their government positions, watch Ruth Bader Ginsburg's Senate hearings, her Senate confirmation hearings, because guess who's questioning her during the Senate confirmation hearings? Joe Biden. As a senator, Ruth Bader Ginsburg is now dead, and Joe Biden is now running the country. Go ahead, Brad.
So I went to University of Delaware.
Oh, yeah.
Yeah. He was like pretty big in there. He was part of like the council.
Yes, he was. Yes. What else did he do? We love when people do this in our country. We worship these people. They have multiple holidays throughout the year.
You're not narrowing it down.
Great point. Yes, the military. Was he not a military service member? What do military service members do? Travel abroad, right? Go to other countries. Generally try to force our version of democracy on them, right? Joe Biden was a part of that. Joe Biden is a military service member. He has children that were. What is also generally true about people who serve in the military and their approach to immigration? Do they have a super pro-immigration approach, or are they generally more in favor of stricter policies? People with a military background. So and also people who have police backgrounds.
So some people have been joining the military to be.
Right? That's 100% true. People join the military to be able to engage in that process of shutting down immigration, right? That's what the military, parts of the military are actively concerned with. So why is he not taking, why, so we're assuming Gen Z is over here. I love Gen Z. I'll do this. Why is he not trying to appear more to here?
But that's not because like in government right now.
Exactly. Who's in government? What would we say the average age of someone in government would be right now? Someone's in- Probably, honestly, like in their 40s or 50s would probably be the average, because keep in mind, the House of Representatives is actually significantly younger than the Senate. The House of Representatives, you only have to be 25 to run. And that's why you see people like AOC who are in your age range actively involved in the legal process there. But in the Senate, you have to be 35 to even run. So of course they're going to push it up. And then president, you have to be 35. And the youngest person was like right at that. And President Barack Obama was like 3 years above that. So if that's who you're targeting. Also, who votes? Unfortunately, the sad thing about Gen Z is, does Gen Z vote? No. They haven't been able to yet. This is the first year we'll find out what happens, right? We can now. You can now. That's right. We'll find out what happens. And some of you will, and some of you will vote.
Do you honestly think if we got to vote last election, we would have voted for Kanye? Kanye would have more votes?
No, I do not think Kanye would have won that election, even if Gen Z was able to vote. Honestly, one of my hairstylist and I had a conversation that she is closer to Gen Z. Actually, I think she would be Gen Z, and I'm technically a millennial. So she is of the opinion that Gen Z might be the first generation to end the two-party system. Thoughts on this? Because we know that there's some pretty substantially big names running for third-party candidate, right? Aren't they?
Yeah, I'm hoping he goes further.
And by he, I assume you mean John Kennedy. Yes.
Oh,
So what's that gonna do? Because I think honestly, John Kennedy, who was also somewhere honestly here with Biden. They might split the votes both directions. Then what happens if both this vote and this vote are split? Maybe we finally do have an end to the two-party system. Or maybe no one gets elected as president. But there's you guys are too old to appreciate the Cat Williams joke, but there was one called Pimpin' Pimpin' right after Obama was elected. And he was talking about how after 8 years of Bush, he just like, why don't we just be single as a country for a while? Let's date a president. How about that? And I feel like every year since then, I've thought more and more about that. Temporary probation period. You can have 6 months. We'll see what you do with 6 months. And then we'll give you the rest of them, we'll give you the job after that, right? That's what we do with police officers, is see what you do with the power you're entrusted with, and then we'll decide if you can stay, right?
I used to watch Masked Singer when it first came out and everybody started like getting around to it, but I feel like we would be better if we could do the elections like by not seeing someone.
Yeah.
Only hearing like their views.
Interesting, because how much did television change who was elected? Because the first year that television was super prominent during the election, a very attractive individual won. JFK, the youngest president ever elected, and on TV, versus who was he running against at that time? It was Nixon. And who is gonna vote for Nixon's? But when we're all like looking at poised, calm, cool, collected,
That's exactly how we got stuck in the niche.
is it not?
Couldn't see.
You could, if you could see Mitch McConnell, would you have voted for him? And we lived in Kentucky, right? What about some of you ever looked up who are the Tennessee Congress people that serve in our districts or serve in the other districts? Let's say the ETSU districts, the Appalachian districts. If you could see them and you could vote for them, I'm guaranteeing you probably would. Television, social media, generally any form of media has a huge impression on that as well. So I think we'll also see, to continue to go along, is it helping Joe to have social media right now? Or to have cameras around him at all times? No. It's not helping him. Weirdly, is it helping him? He literally got kicked off multiple social media platforms, and has that hurt him at all? But who did it hurt? The eagle who can't seem to function with stairs. Has anyone heard that Secret Service clip where the Secret Service are like,
Yeah.
the eagle is coming down the stairs. The eagle has had problems with the stairs before, so just everyone be on alert.
Yeah.
If that's what the Secret Service is saying about you, do you have the social latitude to appear soft on immigration or on crime? If you're trying to appeal to these people and potentially some of these people who might not be too far gone, do you have the social collateral to be able to do that? Now, if he looked like Obama, does he have the social collateral to do that? Maybe, but also maybe not in some other circles, because what's also true about President Barack Obama that is not true about President Joe Biden, other than age? His race. What you said? He what? He did smoke weed. I mean, who doesn't think Joe Biden smoked weed? Joe Biden smoked weed. That man was in Vietnam. He smoked weed. They all did. They all did a lot of drugs. Stop letting anybody lie to you. I wouldn't be surprised if that's the reason that he is so strange now. Honestly, maybe that's how we prefer him. We don't know. Other questions, comments, concerns? Before.
Why do you think Kennedy sided with the majority in this case? Because I've never seen him on the.
Kennedy is a swing voter.
Is he really?
Yes, Kennedy is a swing voter. That's why he was given the opinion to write in Obergefell, because he is a swing voter. And because they wanted the person who is typically most likely to side with the other side to author the opinion, so that it creates the idea is if the person who is most likely to swing or side on the other side actually sides with you on the issue, then it has a lot more persuasive power to have that person write or author the opinion. The Chief Justice also gets to assign who writes the opinion, and a lot of times that's the idea that goes into behind it. So Justice Rehnquist is probably like, hey, I want this to be decided and not overturned, so I'm gonna give it to Kennedy, who was a close call, because then it may like double down or reestablish or the connection and the opinion and make it even stronger. So a lot of times it's a kind of call about, because the Chief Justice assigns who writes opinions. Great question. Anything else? All right, remember that Wednesdays, what happens on Wednesdays? Do we meet in here or do we not?